are over and above the number of seats that we have available. They have generously hooked up a feed in the cafeteria, which I believe, if I'm not mistaken, is directly behind me and right down the stairs. And so it'll be live fed there. So if you have a seat, please take your seat. If you do not have a seat, it will be live broadcast behind us. And of course, everyone knows the kind of seriousness of this State Canvassing Board's work, and we've all approached this very, very carefully, and we appreciate that in the public it's also a very serious matter, and so there's high energy, there's a lot of emotion, but we're dedicated, and we will make sure that we're approaching this with a kind of care and seriousness that this kind of concern dictates. And we hope and expect that everybody in the room and who's part of this process is approaching it from the same perspective that we are, and that's how we will be proceeding today. The first order of business is just to ask for a motion to adopt our agenda for today. Can I have a motion to that effect?
So moved.
Second.
All in favor say aye.
Aye.
Opposed, same sign. The second is I want to have a motion for approval of the minutes from our last meeting. It's the big fat folder inside of the even fatter overall folder.
Mr. Secretary, just for the record, I did make one correction before we got here today. That correction's been made, so I would move to adopt the minutes.
And so they are now corrected based on your correction. Thank you. So we have a motion to accept the minutes as they are in your packet. Is there a second?
Second.
Thank you. All in favor, say aye.
Aye.
Opposed, same sign. The third item is a small detail we have received under attorney-client privilege opinion and guidance from the Attorney General's office on the question of the consideration of wrongly rejected absentee ballots. I would like a motion to waive our right in respects to this specific document for the purposes of this State Canvassing Board meeting.
I would move to waive the attorney-client privilege regarding this document.
I would second that motion.
Any discussion on that motion? Seeing none, all in favor say aye.
Aye.
Opposed, same sign. If I'm correct in my understanding, there are copies of this that will now be made available to the public, and I want to thank the Attorney General's office for getting that to us, and I want to thank all the members of the State Canvassing Board for addressing this issue right away. The first item on our agenda in terms of our State Canvassing Board responsibilities is to get an update on where we stand on the question of challenge ballots. Notwithstanding all the other things, our really big task is reviewing those challenged ballots starting next week. We have with us to give us an update on our current situation our Director of Elections, Gary Poser, who's been appointed as our responsible staff for this particular question. Mr. Poser, are you prepared to give us a report on where we stand in terms of challenge ballots?
Yes, Mr. Secretary and
Please
members.
Proceed.
On November 26th, when we met last, I reported to you that there at that time were 3,594 challenges that had been reported. The good news is that the candidates have submitted over 2,000 withdrawals of challenges. The bad news is that there are totally, after the entire recount was done, there were initial challenges of 6,655. So with the withdrawals that have been removed, we still have a remaining 4,472 challenges that remain, which is actually more than the total that I reported to you the last time we met. That's basically where we stand. We continue to be hopeful that the campaigns will continue to submit some more withdrawals, withdrawing more challenges prior to next Tuesday's meeting.
Thank you, Mr. Poser. Any questions or general discussion?
Can I hear that number again, please?
Of the remaining?
Yes.
Right. So there are remaining 4,472 challenges. There were initially 6,655.
Thank you. Thank you.
You're welcome.
No comment.
No comment?
Oh, I have a comment.
Yeah, that's-
That was a sigh, but
Thank you.
I have a comment.
Please.
And I think I said it the last time, and it has to do with respect for the voters in this state. I hope these challenges are serious. Before the last canvassing vote, there were comments in the press by lawyers or representatives from both campaigns accusing the other side of frivolous challenges or just challenging to catch up with the other side. This isn't about that. This is about every individual Minnesotan's right to vote, right to have their ballot treated with respect. I haven't looked at any of the things on the websites, but you'd have to be deaf and dumb, intellectually challenged to not hear people talking about the fact, hear the public wondering if, in fact, all of these challenges are serious. You'd have to not even hear people talking on the street. I just hope that both sides are respecting every single ballot that they see and raising only challenges to these ballots that are serious. Because it's going to take us a long time. We'll do it. But please, please, be serious.
Thank you. Any other comments?
Well, I just want to echo what Judge Guerin has said. We have a number of people out in the hallways with signs that say count their votes. Speaking for myself, my goal is to count every legitimate vote. And I need all the help I can get to do that efficiently, fairly, and spend the time I need to spend considering the real questions. To the extent that we're asked to look at issues that aren't really issues, it simply detracts from our ability to give fair consideration to those issues that we really do need to consider.
Thank you. Anything else? One of the items that we need to address today in regards to next steps in preparing for our meeting next week is a procedure for withdrawing the challenge ballots that have been waived or taken back, so that we are only left, so to speak, with the ballots that are still not yet withdrawn. Our staff has prepared a brief proposal. It basically describes a process by which in public we would open the original ballots, move those ballots that were previously challenged but now have been withdrawn into a separate packet which would be resealed, so that when we begin our process next week of considering the originals, that they would be absent or minus those that have been withdrawn. And I think we've heard that we hope those final numbers are reasonable and appropriate. But let me read out loud just this proposal. That to facilitate the review of challenge ballots, the state recount official is directed to open the challenge ballot envelopes, to remove those challenge ballots which have been withdrawn by each of the two candidates or their representatives. The state recount official shall report to the board the allocation of votes resulting from the withdrawal of these challenges. The withdrawn challenge ballots shall be sealed into separately labeled envelopes for return to the jurisdiction from whence they were received, so back to the county or to the city. And the state recount official will arrange for this process to occur in an appropriate room and at an appropriate time, and shall inform the candidates and the public of the time and location so they may observe if they so desire. The state recount official may designate any member of the staff of the Office of Secretary of State to assist in this task. The remaining challenge ballots shall be sealed into separately labeled envelopes by jurisdiction from whence they were received and be kept secure for review by the board. I'd like to make this as a motion. Is there a second to this motion?
Second.
Any discussion on this procedure?
Mr. Secretary, I just want to again commend you and your staff for the thoughtful way that you're going about preserving all of the evidence in this election contest. It's a big job. You've done very well. This is just another example of the thoughtful way you've approached it.
Thank you.
Has there been any, Mr. Secretary, has there been any conversation with the with the campaigns about this process?
I myself have not had any conversation with the campaigns. I think the answer would be no, unless somebody from the campaigns want to correct me. But I think, we're basically proposing this to facilitate our process, and we want to make sure that the appropriate time and place is a time and place that's convenient for the public, but especially for the campaign.
It's not my suggestion, Mr. Secretary, that the campaigns need to be consulted in this regard. I would be prepared to adopt this process, but obviously if there are any concerns, they can be expressed to the appropriate official of your office, and then we can deal with them when we get here next Tuesday. So,
Absolutely. Thank you
but I
for that
just
point.
wanted to let people know that if there are concerns about the process, this is not a unilateral decision. We would take input from others.
Absolutely. Thank you very much. Any other discussion? Seeing none, all in favor say aye.
Aye.
Opposed, same sign. Thank you. We will, of course, return to more conversation about how we'll be proceeding next week. I don't know about today or first thing on the agenda next Tuesday, but we will need to be highly organized. And if we get the number of challenge ballots down to those that are truly merit our attention, I think we'll have a very smooth process next week. So I want to add my voice to those urging the campaigns to get these down to what's appropriate. Next item on the agenda is discussion of the ballots from Minneapolis Ward 3, Precinct 1. What I'd like to do is hear from our election official, Cindy Reichert, Director of Elections. I would like to hear from a representative from the Attorney General's office, perhaps from the Attorney General herself. Welcome. Glad that you're with us today. In regards to the earlier guidance from the Attorney General's office, if there's any update according to other law or precedent, but anyhow, to hear from them, and then to hear from all of the state canvassing board members. Maybe we'll just start at that end and move down. Any questions for either Ms. Reichert or the Attorney General? Discussion, and then once we've heard from everyone and gotten our questions answered, then move into discussion of our action. So if that's all right, we will proceed with hearing testimony from Ms. Cindy Reichert, who's Director of Elections in Minneapolis.
Thank you. Thank you for hearing me and for letting me come before you today. My name is Cindy Reichert. I'm the Director of Elections for the City of Minneapolis, also Assistant City Clerk for Minneapolis. Just a bit of background, I've been City Clerk and involved in elections for 12 years now. My 13th election was the one that just passed. And what I'd like to do first is just to give you an outline of the events that happened regarding this packet of ballots that are missing, and just go through the steps that we took to find these. Sometime prior to December 2nd, at our warehouse, we were conducting the recount. This precinct, Ward 3, Precinct 1, came up on our list of precincts to pull for counting prior to December 3rd. We're not sure exactly which day. We were quite busy. There was a lot going on. But at that time, staff noticed that we had unusual numbering on the ballot envelopes. There was one gold envelope containing the write-in ballots that was labeled 1 of 1. We also had 4 white Tyvek envelopes, which are the envelopes we use to transport ballots. Those were labeled 2 of 5, 3 of 5, 4 of 5, and 5 of 5. It was obvious to us at that time that there was no 1 of 5. We thought that perhaps we had just set that envelope on a different ward's pile. We had them stacked in the warehouse on pallets. There's quite a few packets of ballots there. We thought as we went through the process, we would identify if they had been misplaced, that they would come up.
Ms. Reichert, could you just pull your mic closer?
Yes.
Sorry.
Thank
Just
you.
pull it up really close. There are people who want to hear.
All right. On Tuesday, December 2nd, we had finished counting all of the other wards and confirmed that that envelope was not there. Because the ballot envelopes contain approximately 500 ballots each, we knew that the precinct had just over 2,000 voters. We believe that the ballot envelopes may have been misnumbered by the precinct election judges. Now, at this point, we still had not opened those envelopes at all. We did ask one of our staff members to contact the chair election judge to discuss this with him. The chair stated that he had been doing other duties when the ballot envelopes were packed, referred us to another person who we also contacted. That person remembered that there had been 5 white envelopes in addition to the gold write-in envelope. But he was a little bit fuzzy. It had been nearly a month by this time before we had noticed this. The next day, Wednesday, December 3rd, we opened those envelopes for counting. After the table officials noted that the ballots appeared to be missing, our staff, accompanied by campaign representatives, searched through the stacks of all of the ballot envelopes, including our spoiled ballot envelopes, envelopes containing voter receipts, some other materials at the back of the warehouse back where those were. At the time, we looked at the precinct statistics. Now, when I say statistics, I'm not talking about vote totals. I'm talking about number of registered voters, voter registration cards, things like that. We looked at the tape, which has the statistics listed at the bottom of the tape, which you've all gotten a copy of, where the judges actually count things and perform some arithmetic, transfer those numbers onto that tape. Well, we noted at that time that their numbers didn't add up as they should have, so there were some arithmetic errors made. At that time, we speculated that they may have made an error, perhaps run a group of ballots through the ballot counter a second time, which occasionally happens. A count of ballots with the write-in votes was conducted, separating those out, thinking perhaps they had taken the envelopes out of the right compartment of the ballot box, which are votes where there are write-ins, and perhaps run those through mistakenly. The numbers were close, not exactly right. What I agreed to do at that point was to go back to the office, count the materials that the statistics are based on, which is the actual voter registration cards.
There are 2 items in front of us in general terms. One is, do we think there are missing ballots? Do we think the number indicated by the machine is equal to the number of people who voted? And then the second question is what do we do if there are missing ballots, which is what is the report from the election officials responsible for this particular election. We've heard some guidance from the Attorney General's office. I'd like to move to an open conversation among the State Canvassing Board about this. This would be a great thing to tie up if we can.
Mr. Secretary, may I
Please
speak? As I read the Attorney General's opinion and the cases referred to both by the Attorney General and by the parties, the election return that has been presented to us by Ms. Reichert is prima facie evidence of what occurred at the precinct that evening. If someone seeks to challenge that, they're free to do so, but they have to have some evidence. And as the Supreme Court said in Moon, if you don't have the ballots, you don't have any evidence. I believe that we have a good system for checking, to keeping track of ballots. No system is perfect. I believe that the officials here have acted in the best interests of the public in preserving the records and conducting their search. I also have no doubt that whatever we decide here today may be subject to proceedings in an election contest, which is certainly the right of the parties. But it seems to me that we have no authority and no reason to direct the city of Minneapolis to report anything other than what they have reported to us. And I would make a motion that we accept the vote total results that they've presented.
Thank you for that motion. Is there a second to that?
I'll second it.
Thank you very much. Is there any discussion on the motion?
If I might, Mr. Secretary, Ms. Reichert, I'm in general agreement with what the Chief has outlined. I would also note I'm not so sure as to when this question gets ultimately resolved that Moon controls here. I think the lawyers can argue about that. There is the possibility of an election challenge. There are other procedures that may be available to the parties to deal with this issue. But as I said when we gathered earlier with this group, it is my view that we are in an administrative and ministerial capacity, not an adjudicatory capacity. And I think that we have prima facie evidence, and I would, on that basis, be prepared to accept that and to support the motion that has made with the clear understanding that ultimately some court, some judge somewhere may reach a different conclusion, and that's how the process works.
Excuse me, Mr. Secretary.
Thank you very much.
Council has suggested that we make clear that it's the 2028 that that's the total that we are motioning on this?
Yes, if I can state the motion that the State Canvassing Board accept the machine totals as reported by the City of Minneapolis for the purposes of our canvass of this 2008 election.
Yes, that's what I meant to say.
Second, is that okay? Seeing no more questions or discussion, all in favor, please say aye.
Aye.
Opposed, same sign. Thank you very much, and to both Ms. Reichert and to the Attorney General's office, this is all way above beyond the call of duty, but it is actually your demonstration of what duty means to you that has been so encouraging to us on the Canvassing Board for all the work that you've done. It was a big election and a really tough thing to get through, and thank you for helping us move through this process as efficiently as we can, and thank you for your diligence in getting us the information we needed to be able to move forward. Thank you.
Thank you, Mr. Secretary, and if I might just also say thank you for myself and on behalf of my election judges. We believe very strongly in making every vote count, and it's our life's work, and I appreciate your support. Thank you.
Thank you very much. We'll move to our next item, which is the presentation on kind of preliminary results. What have we found out from counties and municipalities about the sorting of wrongly rejected absentee ballots? I would like to, use the same general approach. I believe that Deputy Secretary of State Jim Gelbman will give us a report on what we've heard. We'll ask the Attorney General to again just briefly review the memo, which is the guidance letter, which is now public. And then we'll just start and go through us again, and then we'll move to a general conversation. But thank you again, and we'll proceed with just a general report on what have you found out so far.
Mr. Secretary, members of the board, my name is Jim Gelbman. I'm the Deputy Secretary of State. At the November 26th meeting of the State Canvassing Board, the State Canvassing Board requested staff of the Secretary of State's office to work with counties and cities to sort the rejected absentee ballots. They asked us to sort those into 5 piles, the 4 reasons for rejection of absentee ballots, and a 5th pile of ballots that were wrongly rejected by either an absentee ballot board at the county level or at the precinct level. The purpose was to understand the magnitude of the number of absentee ballots that were wrongly rejected through no fault of the voter. We had very good cooperation from the counties and cities, although many are concerned about the large number of data practices requests being made of them. Thus far, the sorting continues through the end of next week, but thus far, 49 counties and municipalities have completed their sorts. 3 have completed their sorting but have not yet reported their results, and there are an additional 24 sortings projected to start today or sometime next week. Of the 49 counties and cities that have reported their results, there have been 4,823 rejected absentee ballots looked at. In other words, election judges have actually taken the absentee ballot envelope and looked at it, looked at the reason for rejection, and determined whether or not the reason for rejection was indeed accurate with the facts of the case. 638 of those 4,823 absentee ballots have been determined to be wrongfully rejected.
Now, Gelbman, may I ask you, who has made that determination? Is that the local election officials?
Mr. Chairman, Your Honor, yes, that is correct. It's the local election officials, or in some cases, it was an election judge that was hired by a trained election judge that was hired by the local elected officials to come in and assist with this process.
Okay, so we're just getting a double check from the local officials on this.
Mr. Chairman, Your Honor, that is correct.
Thank you.
That leaves us with a rough average of 13.2% of all rejected absentee ballots appear to have been wrongfully rejected, based on a review by qualified local election professionals. If that trend holds true for the remaining reviews that will continue throughout this the next week, it would show that we would estimate approximately 1,587 wrongfully rejected absentee ballots would exist throughout the state of Minnesota. Again, using the 13.23% number to the approximately 12,000 rejected absentee ballots that people have estimated exist throughout the state. I'd like to bring to your attention one situation in particular. Although the city of Duluth and St. Louis County have not agreed as of yet to participate in the sorting of absentee ballots, the St. Louis County Auditor's Office has provided me with a spreadsheet listing the reasons for the rejection of 319 absentee ballots from the city of Duluth alone, not from the entire St. Louis County. What they did is created a spreadsheet and simply wrote from the envelope, from the absentee ballot envelope, the reason why the absentee ballot was rejected. Of those 319 rejected absentee ballots, 99 were rejected because the witness that witnessed the person filling out the absentee ballot did not date his or her signature. 21 were rejected because the voter did not date his or her signature, and 7 were rejected because the voter and the witness did not date their signature. So of the 319 rejected absentee ballots in the city of Duluth, there are approximately 40% of those absentee ballots were simply rejected because there was no date on the signature. We have reviewed with council and the Secretary of State's office both the statutes and the rules governing absentee ballot voting, and there is no statute or rule that we could find that actually requires a date on the signature.
Thank you, Mr. Geldman. Attorney General Swanson, your office provided us with a memo of guidance about what might be done to address what looks like is a significant number of wrongfully rejected absentee ballots. Would you like to give us a brief summary, and then once you're done, we'll move to questions. Jim, Mr. Geldman, if you could wait, I would like to hear from Attorney General Swanson, and then
you're not done yet.
Yeah, you're not done yet. I have questions. Thank you.
Not so easy.
Attorney General Swanson.
Mr. Secretary, members, we did provide an opinion pursuant to the request of this canvassing board at the last meeting. And we start with the premise that every lawful vote should count in a democracy. And really that's a right not just of the voters themselves or a right of the candidates, but a right of the entire electorate, that in a representative democracy, every lawful vote ought to be counted. And people ought to have a right to elect who their leaders are, and that ought to be the leader who gets the most votes in the election. We outlined in our opinion 4 statutory procedures that were passed by the Minnesota legislature to allow correction of errors. And as I understand it, what we're dealing with here is the so-called Pile 5 and some subset of voters who did everything right on Election Day, followed all of the rules that were put in place for them by the government of the state of Minnesota, and yet had their votes rejected due to no fault of their own. You may have other provisions of the statutes in mind as well. We outlined as well the case law, which has 2 recurring themes in it. One theme, again, is that every lawful vote ought to be counted. And second, that canvassing boards are given wide latitude and wide authority by the courts, primarily citing the 2 cases, Anderson and in-ray school contest litigation, where so long as canvassing boards are acting in good faith to ascertain the will of law-abiding voters, their decisions are sustained by the courts. It is difficult for me to find, as we looked at the laws, a particular statute that says that this body could take the Pile 5s and count them themselves. And there aren't precise statutes that say that this body could order a county to do something, because you're not a court and there aren't procedures in place for contempt and fines. I do believe, however, that this body can request that the county canvassing boards reconvene for the purposes of tabulating improperly rejected absentee ballots, and then can thereafter give you amended reports which you may accept, setting forth any new tallies for the candidates based on that review.
Thank you very much. We'll start with questions and just move down, and then we'll go to discussion.
I don't have any questions of Mr. Gilman. I have some discussion coming, but we'll wait for that.
Thank you.
I have a question for Attorney General Swanson, Mr. Secretary. Am I correct in my understanding that there is no precedent for this board having issued an order to county canvassing boards to review and consider, however this might be determined, wrongfully rejected absentee ballots? Am I right about that?
Mr. Secretary, Your Honor, a very similar case is the case of Anderson. And as you know, in Anderson, what had happened is that 10 counties, canvassing boards, reconvened after they submitted their initial reports to the state canvassing board for purposes of correcting obvious errors. And thereafter, they were fed their new amended reports into the state canvassing board, and the Minnesota Supreme Court allowed those reports to be tabulated and corrected. What I believe is that there is nothing to prohibit you from making a request to the counties that their canvassing boards reconvene for purposes of correcting these obvious errors, and thereafter nothing that would prevent you from accepting amended returns pursuant to the case law set forth in Anderson.
Chief Justice. Well, Judge Guerin.
As I hear your recommendation, I think you're kind of saying that we have authority to take two actions today. One would be to recommend to the local canvassing boards that they review and count rejected absentee votes that were rejected for a non-statutory reason. And two would be a second action that you believe we can take, and that, if we want to, and if we believe it's appropriate, and that would be to accept any amended reports from the county canvassing boards that did that. Now, it's my understanding that some county canvassing boards have already done it. So we're going to have to make a decision on part two, no matter what, whether we accept the county canvassing board's amended returns that did separate those rejected absentee ballots, and for ones that they couldn't find a statutory reason, where they believe they made a mistake, are counting them. So we have to do something about that no matter what. But the other thing, as I see it, I think it's a two-part thing that we need to deal with today. Am I understanding correctly?
Mr. Secretary, Judge Guerin, you are understanding correctly. I believe the law does allow you to make that request to the county canvassing boards, and if they do submit amended reports, I also believe that you have the authority to accept those reports. We are primarily a county-based system, starting on election night, where you have the election judges on a volunteer basis making their tabulations, feeding their reports into the counties, and then ultimately feeding them all into you. You are the acting as a state of Minnesota today. You were established in the Constitution well over 100 years ago, and so if you make that request to the counties, I think you've got the authority to do it, and that would be my recommendation.
Okay, if we don't recommend to the county canvassing boards that they accept, or that they basically count those wrongfully rejected, non-statutorily rejected absentee ballots, it's going to be part of an election contest. If we do, it'll probably be part of an election contest too, but I'm really having difficulty understanding why we wouldn't count.
Well, let's finish questions, and then Chief Justice.
Mr. Geldman, have any of the counties or municipalities actually submitted amended returns based upon their review?
Mr. Chairman, Your Honor, I believe the only one that I'm aware of, and Mr. Poser could possibly help me on this, is Itasca County, I believe, has submitted an amended return based on the counting of 3 absentee ballots.
Mr. Chairman and Your Honor, I'm not sure if something was done during the recount, where some things were put within the recount totals as being absentees that were counted as part of the recount, but nothing as far as submitted through a county canvassing board report that I'm aware of.
Okay, thank you.
But they still have, I mean, that was my question at our last session. They still have time to do that. Until we certify the election results, we can get amended returns from the counties. And St. Louis County is the only county so far that has said they're simply not going to do this?
Mr. Chairman, Your Honor, there are a number of counties that have declined to do this thus far. Several have actually said no. The others have simply not responded to our request. A number of the ones that have said no have basically said that they wanted to wait and see what the canvassing board does today to determine if that exercise is going to be useful.
Thank you. Attorney General Swanson,
Yes.
The opinion from your office, which I found very helpful, makes it clear that there are specific statutory procedures that either of the parties here can follow if they believe that a county is failing to correct an obvious error. And it's a simple petition to the district court for an order compelling the error to be corrected. Am I reading that right?
Mr. Secretary, Mr. Chief Justice, that is one of the statutory processes that can be followed as an order to the district court. Under 204C.39, a county canvassing board on its own initiative as well can reconvene for purposes of correcting obvious errors.
Okay, and 204B.44 says a petition can be filed in the Supreme Court, but, and this is just following up on what Justice Anderson, I believe, asked, there's no similar provision that says we have the authority to make the county boards do anything, right?
Mr. Secretary, Mr. Chief Justice, looking at the statutes, we haven't found a statute giving you authority to enter orders, correct?
Thank you.
Correct.
Thank you. Those are all the questions I have.
Any other questions to either Mr. Gelman or to Attorney General Swanson? Seeing no more questions, I'd just like to move to discussion.
All right, Mr. Secretary, the last time we met on November 26th, we unanimously agreed that we were not going to consider rejected absentee ballots. When I agreed with that vote, I did so with the express stipulation that the fifth file, that is, those absentee ballots that were uncounted, because there was no reason under the statute, and there are only 4 reasons given, to reject the absentee ballot, that those be still considered, because I don't believe those to be rejected ballots. I believe those to be uncounted ballots. Since that time, it appears some counties have voluntarily separated their ballots into those 5 piles that we referred to. It appears to me, again, that there is absolutely no reason why that 5th pile should not be submitted to this board, subject to challenge by either candidate for intent. But I come back to the fact that the only reason why we can't look at the rejected absentee ballots generally is because we do not have authority to make findings of fact and conclusions of law on the 4 piles that are rejected for reasons. We can't consider the reason for rejection and the reason why the voter feels it shouldn't have been rejected, because that does take an election contest. The 5th pile, that is, those that have been identified by election officials, not by either candidate, by election officials, and as having been improperly put into the rejected pile and are uncounted votes, in my opinion, should come to us. They should be opened, and they should be counted. And the bottom line is, I think we're disenfranchising voters who followed the command of the law, who submitted the absentee ballots according to law, and it would be unjust and disrespectful to those voters not to count those votes. So I understand there's a 2-part motion, and I may be premature. I certainly understand the Chief Justice and Justice Anderson's position that we can't force county canvassing boards to do this. But I certainly believe that we should recommend that they do this. That is, separate the absentee ballots into 5 piles, and that 5th pile should come to us in the way of a report from the county canvassing boards amended after they've done that. So that would be my position. I'll withhold any motions till discussion's over.
Please.
Mr. Secretary and other members of the canvassing board, I agree wholeheartedly with Judge Cleary. The idea here is to count ballots that were properly cast. I believe that the election officials are making a good faith effort to go back, figure out where they may have missed the vote, and fix it. And I would be very surprised if they refused to submit to us amended returns. When we get an amended return, I believe we consider it. I do not believe we have the authority to force them to do that. but there are clear statutory remedies available to the parties if they believe that there is an obvious error. They can petition the district court under 204C3, 204C39. The district court has the power to issue a compulsory process, to hold an evidentiary hearing, to call witnesses, and to enforce its order. And so while I am gratified at the efforts that have been made on a voluntary basis, and while I am hopeful that the election officials who have performed so well to date will continue to perform well and do what is their duty, until we get an amended return, I don't believe that we can take any action. And so I'll let everybody else talk.
I concur with Mr. Secretary and fellow judges. I also concur with Judges Cleary and the Chief Justice Magnuson in their comments. We do not have the authority to order a county canvassing board to do this. I find it difficult to understand why some counties wouldn't do it. People showed up and had to make efforts to get their absentee ballots. They did it. They wanted to do this. Ordinary citizens want their vote to be counted. They followed the procedures. I just don't understand why some of the counties wouldn't want to do this. I think I guess I should be a little more understanding. Part of it is they've had a lot of burdens already. I need to be more patient with that. Our local election officials have had a lot of burdens just with the number of people who showed proudly in Minnesota, showed up to vote. And absentee ballots are more complicated to handle, and they do require more scrutiny. But if they find the local people in the trenches find they made a mistake, that vote should be considered.
Thank
And
you.
I think we can only recommend and we can accept, just as the other two judges have said.
Thank you very much.
Mr. Chairman, Mr. Secretary, members of the panel, I'm inclined to go along with Judge Cleary's motion, but here's my concern. Absentee voting in Minnesota, we talk a lot about counting every vote, but absentee voting in Minnesota is a privilege. There are specific rules that must be followed. I suspect that Pile 5 isn't Pile 5. It's Pile 5 and about 4 or 5 subdivisions to Pile 5. And by that I mean, my guess is that there are going to be obvious examples in Pile 5 of votes that the canvassing board probably should reconvene and consider. For example, we had some discussion at our last meeting about ballots where there's nothing on the ballot. There's absolutely nothing. There's not even an indication that the ballot was rejected. Now, it seems to me, as a practical matter, in terms of complying with the statute, it's pretty hard to argue that that's a rejected ballot, or at least there's a better argument for those kinds of ballots than maybe for some other kinds of ballots that they should be considered. So I'm not troubled by a suggestion from this board, a recommendation, recognizing we don't have authority to order it, that counties look into that issue. But I also have to say that there are statutory requirements here, and I suspect there may be, for example, we had some discussion about whether or not people were duly registered in a particular precinct, and there are submissions today arguing that. Those are not facts. Those are allegations. And I think we need to be very careful about this. And one of the reasons why I'm willing to support the motion is this is not the place to do that fact-finding. So I'm willing to go along with the recommendation, but I think it's not only a function of every ballot counting, as the Attorney General has said. It's a function of every legal ballot, every lawful ballot being counted. And that's an important factor here that I don't think we should lose sight of. So with that caveat in mind, I am likely to go along with Judge Cleary's motion.
Well, thank you very much for keeping us underlined on this being a very careful process. And these, I think what we've been talking about are the things that we would all agree would be obvious errors. But of course, what we're discussing in terms of a two-stage gives us also the opportunity to review that when it comes to us. What I hear is the motion, and I want to make this just to make sure we're all, that we are saying the same thing. that I would move that we recommend to counties that the county canvassing boards review rejected absentee ballots for the purposes of identifying obvious errors and for correcting those obvious errors and reporting their new totals to the state canvassing board for review.
Can I make that a little bit more precise legally?
Please.
Okay. Sorry, we can't resist that. I'm going to recommend, and I'll just restate it slightly different, that the county...
Slowly, very slowly.
The county canvassing boards, those who have not already done so...
Just keep going, all right? I'm trying to write it.
Reconvene and separate rejected absentee ballots into 5 categories. First 4 categories would be those statutory grounds found in 203B.12, subdivision 2, for proper rejection of absentee ballots. The 5th pile would be those where there is no grounds or reason for the rejection of the absentee ballot because it does not meet one of the 4 statutory reasons. Pretty much what you said, only more difficult.
Keep going.
That's it. I mean, that's part 1. I mean, I'm presuming this is going to be a 2-part motion.
Right.
Is it okay with everyone we take this in 2 pieces?
I think it's better.
Excuse me, Mr. Secretary, council wishes to clarify.
Since we also have UOCAVA overseas voters included in that, which have a different set of standards, could we also include the provisions in 203B.24 for those voters?
These are the military ballots?
Yeah.
That's correct, Your Honor.
That would be a friendly amendment to the motion and should be included.
Okay, we have a motion that has been amended in a friendly way to make sure that the military voters' provisions are included. Is there a second to this motion, which is part 1 of 2 parts that we will do?
Second.
Any further discussion on this amendment? Right. So this motion as amended now, which moves to recommend to all counties that they do this, we now have in front of us. Is there any further discussion or any other amendments to this motion?
Mr. Secretary.
Please.
I fully support the spirit of the motion. I'm a little uncomfortable with us as a canvassing board whose job it is to review the actions of the election officials, even recommending to them that they take certain actions. They are independent officials who are charged by statute with certain responsibilities. And while I think in the end a recommendation is just a recommendation, I'm uncomfortable directing them to do anything. What I would hope that they would do is what we are suggesting, and I hope that we get some amended returns so that we can get down to the business of actually looking at the ballots and get this thing done. But while I think I'm going to vote for the motion, I want to clearly state that my view is that we have no authority to force anyone to do this. And it is clear that there is a statutory remedy for anyone who believes that the county election officials are committing an obvious error one way or the other, including or not including it. And that's 204C39. You can get into court, you can get it resolved, and we can get on to the business of counting.
Thank you. I just want to say that I share that general sentiment. I'm for the least complicated as possible, but I'm happy to support this because it is just a recommendation. But I want to be as least prescriptive. I want every county to feel very comfortable that they can decide and that they can move forward, and that we will be respectful of how they decide to do this.
Mr. Secretary, I just want to note that I join in the Chief's reservation. At the end of the day, though, I think I'm going to vote for the motion, largely because I'm not sure that the semantic difference between suggested and recommended is a productive use of the next couple hours.
Thank you.
I guess that makes me the only comfortable one here.
There you go. Okay. I'd like to, unless somebody else has something else they would like to say on this particular point.
I think it would be useful to have, I'm going to make trouble here for somebody, but I think it'd be useful to have the motion restated. Could we have that, done? I'm looking at our.
I have bits and pieces of it.
Why don't we just take the time to give her time to write it down so it can be restated? This is important enough. Maybe we should relax and have Judge Cleary look at it and see if it's right. We're moving along pretty well.
Just a moment.
You need the friendly amendment in there, too.
While we're doing that, can I correct something? When I was talking about respect for the voters at the beginning, I used an old-fashioned phrase that may have been insensitive to people. What I'm meaning is this. And I guess I am the senior person, so most likely to use an old-fashioned insensitive
We might
phrase.
need the Attorney General's opinion on that.
Yeah. Somebody could have said, "Oh, that can't be true," but what I mean, to rephrase it in a better way, you would have to be totally isolated from either written, spoken, either any media to not know that the citizens of this state are very frustrated with how long this proceeding is taking place, even though I think it's going orderly and it's going respectfully. I just, again, urge both sides to make sure you're respecting every individual who went to the effort to vote with your challenges, and you've done away with what both of you said in the media earlier were non-serious challenges. And I apologize if I said anything that was insensitive.
Mr. Secretary,
Please.
while they're drafting over there, maybe I could suggest that it would be more appropriate for us to refer to allegedly wrongfully rejected
Thank you.
ballots, since we are not making a
Kate, did you
decision that they are
hear
not.
that?
There goes the legal.
Yep, thank you.
Yeah, now we go to wordsmithing.
And Kate, you have this?
Here's what I have.
Okay, but carefully and slowly.
That Judge Cleary makes a motion that the State Canvassing Board recommends that county canvassing boards that have not already done so reconvene and separate absentee ballots into 5 categories. Sorry, allegedly rejected absentee ballots?
Allegedly rejected.
Okay.
Well, rejected, it's
It's
grounds.
allegedly
Wrongly.
Allegedly.
Rejected absentee ballots.
Rejected absentee ballots into 5
Like
categories.
lawyers.
Okay. The first 4 categories being the reasons for rejection set forth in Minnesota statutes 203B.12 and 203B.24. The 5th category being those which are not included in any of the 4 categories for rejection.
And Mr. Black, does she have in there the language that you need for the military votes?
Statutes.
Yes.
Okay.
Yes, Mr. Secretary, Your Honor, that is 203B.24.
Okay, thank you very much.
Okay, and this is part 1 of a two-part
Yes.
motion. Hearing and seeing no further comments or discussion, all in favor of this.
Mr. Secretary, I think you have to have someone second it first.
No,
I did.
Oh, you did?
Judge
Okay.
Karen
I did.
All right.
Judge Karen
Thank
did.
you, but thank you for keeping an eye on me.
Sure, absolutely.
All in favor, please signify by saying aye.
Aye.
Opposed, same sign. The part 2 is the incorporation of corrected obvious errors into the county canvassing report to be submitted to us for our review. Am I correct in this?
May I ask a question, Mr. Secretary?
Yeah.
And Judge Cleary? I don't know that we know that we're going to get these.
Okay.
Sounds like maybe we will,
Okay.
but it strikes me as premature to take any action on them, other than, I think we've all stated on the record that we believe that we are authorized to accept them, and we hope that we get them. And when we get them, it seems to me that's when we take action. Judge Cleary?
I tend to disagree with that, particularly since we're almost into January here. I would prefer to get things moving and set the framework for acceptance, if that's the sense of the board. In other words, we know from Mr. Geldman that there are already a number of counties that are well underway and some that have completed. They're going to be ready to submit and will not be able to submit until we give them the authority to do so. So I would just as soon go forward.
If I understand correctly, statute, the counties have the right already under statute to identify obvious errors, to make corrections, and to submit the correction to us. Am I correct in this? I see a lot of lawyers looking over books that.
I'm sorry, Mr. Secretary, what was the question?
I'm myself very much share this concern about the time and the process, but my understanding of the statute is that counties have the authority to identify obvious errors, to correct their canvassing report, and to resubmit it to us.
Correct.
That's done.
Correct.
Okay, now, is there more we could do to move the time?
Well, Mr. Secretary, let me just ask you procedurally, since I have not had the privilege of serving on the canvassing board before. From a process standpoint, we haven't voted yet to accept any reports from any of the precincts, correct?
True. That's true.
And we're going to do
That's
that
correct.
after we look at the challenged ballots. So it seems to me simply premature to decide we're going to accept amended returns when we haven't accepted the initial returns, and we should let that all sort down. I think if we, having made our position clear, if we start counting at the crack of dawn on Tuesday, the returns will catch up to us before we're done, I would bet.
And we are supposed to be done by dusk on the 19th, and so that puts some frame. Yes?
I just want to inquire, General Swanson, your opinion indicates at the close that we're within our authority now to accept the amended returns from the county canvassing boards. Do you see a problem? Is that premature, in your opinion, legally, in our acting now?
Mr. Secretary, Judge Clary, I think you could choose to do it either way. I think what's important is that the clear request be made to the counties as to what this body, acting as a state body, want the counties to do, which is to retabulate and make this pile 5, and then to that if they submit it, it would be accepted. I think the counties need some clear direction. Whether you decide to do the full motion right now or do it in a multi-phase process, I think it's your prerogative.
Let me just suggest, in my own opinion, is that if we're asking them to go to this effort, I think they'd like to think that it's got an end game to it, that it's actually going to get here. We're trying to inspire these poor people to go back and do this some more. I would like them to know, that, at least in my opinion, is that we should accept them when they're done putting in those hours of work.
I think the dilemma we face is that we want to really strongly urge people to do this, and in fact, there are other procedures that might force them to do it, but the county election officials that I spoke to mostly wanted to hear from us first our recommendation that they do this, and I think we've stated pretty strongly that we want this done because we all want anyone who was wrongly rejected to have their vote counted, and that implies and should be a message to the county people who've been asking me and others that we would like this done soon, and we would like amended county canvassing reports. If they're going to be corrected, we would like those soon, because the 16th through the 19th is when we are dedicated to making this done. I feel like that's been a pretty strong message, and I'm wondering if as a state canvassing board, that's a strong enough message, or if there's some other underline or point we want to make to this. Justice.
Mr. Secretary, I understand the sense of what Judge Cleary is suggesting here, but my view, and it may be an excess of caution, I don't have Judge Guerin's experience, but after 10 years as a judge, I said experience, Judge Guerin. That age, experience. But my view on this is I don't like making a decision I don't have to make, and I don't think I have to make this decision today. So I would be inclined to just say we've made our recommendation, and then we'll see what transpires here. We're in very much uncharted water, I think, and I think that's a complicating factor for me as well.
If that is the sense of the board, certainly I will agree with it. I'm trying to figure out in my own mind, though, now that we've given them that direction, we're withholding saying that we'll accept the amended reports. What is it that's going to happen between now and then? I mean,
as a practical matter, while I can say in the abstract that I'm inclined to accept amended reports, until I see an amended report and look at it and say, oh yeah, that's okay, I'll accept it, I can't commit to accept it. So I simply want to have them presented to me so that I accept them in the ordinary course of things. And although I think we've made our intent pretty clear, I don't have anything to accept right now.
So it wouldn't be necessarily the number of ballots that make the fifth pile or any of those variables. It would be just that we physically have it in front of us.
To me, the process is really clear. Local county officials count the votes, and they send us reports. And we accept the reports. And if somebody wants to challenge the report, then we look at the ballots. And if we look at the ballots, we can change the report at that point in time. But we don't direct them on how to make the reports or what they should say. And so to be orderly here, it seems to me, although we have stated our sense of what we are likely to do, we have to wait and get the reports, and then we can accept them.
Right. And the understanding is that would be done within 1 week?
Yeah.
Judge,
I don't
you've
know
been trying
how
to get
long.
in on
You
this.
know, well, I don't know that I have that much to add, but I agree that at first I came in thinking that I would like to make a motion from the last or the second to the last paragraph that we accept amended reports from county canvassing boards that include absentee ballots of voters that were wrongfully rejected, or obviously rejected for obvious errors, whatever phrase we want to use. Now I don't think that is the right way to go. I think, from what I've heard here today, there is just, I can't think of a reason why we would not accept the amended report regarding these absentee ballots. I just can't think of any, but it isn't before us, and that I have logical problems with that.
I'd like to weigh in on this because it seems like the longer we talk about this, I think it gets us away from having a very clear message, which is we would like to recommend to the counties and to the canvassing boards that their canvass be reopened for the purpose of examining obvious errors in the area of allegedly wrongfully rejected absentee ballots, and that if obvious errors are identified, that their reports are amended and they are sent to us. And maybe we need to, change the wording so that the final part of the amendment says those reports are opened, amended, and sent to us. That doesn't commit us, but it does tell the folks at the local level that we expect them to come to us. Is there comfort with that, just to add a small 3-word or 4-word thing at the end that clarifies this?
At the end of what?
The motion ends a little abruptly from my point of view, and maybe we should have the motion read one more time.
I'm not sure there is a motion.
The first one, because there's not currently a motion on the table, sir.
Yeah,
No motion on the table.
Right.
So amending the first motion to just say that the result of process is the opening of the canvass report, amending of it to reflect the correction of errors, and the submission of it to us if there's a change.
Well,
go ahead.
Mr. Secretary, I think I've been fairly consistent. I don't think we can or should tell the local election officials what to do. I think we can tell them what way we're leaning, what we think makes sense, but we're not in the business of directing them how to do things. They understand that by the time we're done counting, we're going to certify the results of the election, and if they don't have the amended returns to us, they've got a problem.
They're out of luck.
And if it looks like that's going to happen, then the parties have a recourse to district court. But I think we're micromanaging at this point. I think we've done what we need to do.
Thank you. Any?
Mr. Chairman?
Yeah.
Can I just ask for clarification here? Because I heard the comment made that we haven't accepted any of the county canvass reports. We haven't accepted the results from the recount, but the recount results do not go to the county canvassing board as the canvassing body ordering the recount. All of those recount results are coming straight to this canvassing board to be accepted. So I believe this is going back to the canvass reports that initially we accepted at the first meeting to say these are our official results, and this is what triggered the recount in this particular race because we didn't meet the 5%. So we have already accepted the initial canvass reports.
Right.
And so I guess I'd just like clarification. I believe what would happen here is that we would still then get our results from the recount that are still being processed along with these challenges, and then I believe you would somehow have to incorporate any changes made to the initial canvas reports and add those to the recounted results.
So they would send to us corrections based on their original canvas reports for, if there are any, that then we could review at the level of the state canvassing board because we're in the canvassing phase.
Right.
I think that simply points out the danger of us going ahead and deciding things when we're not quite clear on what it is we're deciding because it's not in front of us. So I think that we've accomplished what we can today.
I feel comfortable that we have made a strong recommendation, and clearly we want every error corrected, but we're not laying out the specific ways in which that's going to take place. The counties and the county canvassing boards have their responsibility and statutory authority to correct obvious errors, and we look forward to hearing from them as soon as possible. I might put an underline on the fact that we are planning to do this review of challenge ballots from the 16th to the 19th. I've been very appreciative of all the paper I've been receiving from the two campaigns, but I fear that they are doing the paper in a way that has taken away from the time they can devote to reducing frivolous challenges, and I'm not happy about this. And I'm going to manage this process so that we're done on the 19th, and that's a message to the campaigns, it's a message to the counties, it's a message to the citizens that we're going to remain efficient, but we are going to put careful attention to challenges that have merit,
Mr. Secretary,
and that everyone should hear this message. Yes, please.
I just have a question, clarification on what we just decided about the amended canvassing reports. We're going to go ahead with our recount next week. These amended canvassing reports may or may not come in depending on whether they follow the directive, or I shouldn't say directive, recommendation that we've given them. We're going to take them one by one? Is that what I'm hearing now? To decide whether to accept each of them?
I think we haven't yet set a procedure, but we've been taking everything pretty one by one and pretty carefully, and I would say slowly and deliberately, and I don't see any need to change that process.
Well, no, I guess what I'm asking is more legal than that. Do we have to have a motion to approve each of these amended canvassing reports as they come in upon deliberation?
Judge Cleary and Mr. Secretary, it seems to me that we can use the same approach that we used, and I'm not sure what the best approach would be. I think that is something that maybe could have some discussion about, but it seems to me we could use the same approach we used when we first met as a canvassing board. There may be very minimal changes. There may be, we may be able to adopt them with a single motion. I wouldn't rule that out, but I also think it's possible. As I said earlier, I don't think we should assume that there's just 1/5 pile. There might be problems that we have to deal with in some session, in some way, with some individual county's canvassing report, and if we do, then I think we need to take it up in that order. But I think it's also possible that we may just simply approve all of them, and I think we're just going to have to wait and see what we get for information from the counties. At least that's my view.
But to prove all of them, of course, if they come in different dates as they're likely to do.
Yeah, I have had a lot of confidence in our ability to kind of keep the ball rolling and to keep things moving. But I also would like to hear from all of you if you're feeling like the procedure is either going too fast or too slow or not well managed, because the consideration of your everyday work, very important work to the citizens of Minnesota, is very paramount to me, but the accuracy of what we do is the top priority. So I want to keep a good balance, and if you feel like I'm not managing it properly in that balance, I want to hear about it.
My only concern, and it goes back to what I was suggesting, and I understand it's not the sense of this board at this time, is that as these amended canvassing reports come in, now that we've recommended that they do so, that we're going to be engaged in a recount. And I'm not quite sure logistically how this works. Are we going to stop that recount, debate whether or not to accept this amended canvassing report or not, and
Yeah,
go back
and
to
I
the recount?
cannot answer that question today.
Okay.
Are you really think we can get done with this by the 19th if they here's the deal.
Yes, ma'am. And if they've heard your voice, and if they've heard the Chief Justice's voice, and Justice Anderson, and Judge Clary's, they will help us with the process. That's how I feel about
That's
it.
good.
Yes,
Well, I
ma'am.
hope they will.
Any other business for the State Canvassing Board today?
Can I make one comment about the number of ballots, because I've been very quiet on that particular topic?
Yes, I was
That's the only
wondering,
topic
we'll
I've
give
been
you the
quiet on.
last whack.
It seems to me that the danger for both candidates is that meritorious challengers are going to get swamped in a sea of frivolous challenges. And we only have so much attention, so much strength to give to these ballots. After a while, it's going to start to blend in. I don't think we're doing either candidate service by this number of challenge ballots. You know when they're frivolous. We know when they're frivolous. Don't make us tell you that.
Thank you very much.
We really urge you to get that number down.
I'd like to move to recess at the call of the chair. Is there a second to the motion? Discussion, all in favor say aye.
Aye.
Opposed, same sign. Thank you.